SJC-12556, Commonwealth v. Pedro Vasquez.
Mr. Schnipper, good morning.
Good morning. May it please the court. I'm Merritt Schnipper for Pedro Vasquez here today. So for years, and really for centuries, this court has said that for first-degree murder suspects or people charged with first-degree murder, the question of bail is solely left to a judge's discretion. That's the common law of bail as it existed all the way back in colonial times and in England before that. But what the court has never said, or really never done, is described how judges are supposed to exercise their discretion in these cases so that as to ensure that the decision is actually made consistent with fair standards and thus with due process. So what I'm arguing to the court and what I argued below but didn't succeed on is that the only thing that, we're outside the bail statutes, and the only thing that we have to guide us is the common law of bail, which says, as this court said in Baker back in 1961, that the bail in such situations is left to the facts and the discretion of the judge based on the facts and the circumstances of the particular case. So there's no real way to interpret that language except to see it as meaning that the judge must make an assessment of the particular evidence against the defendant, the likelihood of conviction, and then the likelihood the defendant is going to face the natural life sentence that's a consequence of conviction, and that based on the likelihood of conviction, this person is a flight risk in a sense that they would not otherwise be if they were charged with a lesser offense. Because in this particular case, we have a defendant before the court who I don't think there's any serious contention that were he not charged with a capital offense, he would be eligible for bail. I mean, he really has no record of defaults. He has no meaningful criminal history. He's from the community, he has multi-generational presence there. There's no reason to believe he wouldn't appear for court. It's the only reason to believe he wouldn't appear for court, and that's the only reason to hold him for the almost 4 years he's now been held pending trial, is if there's no other mechanism that the court can use to ensure that he appears to face trial and eventual punishment if convicted.
There's a lot of big picture issues, but before we get into the big picture issues, just to be really granular and get into this case and whether or not the single justice abused discretion in determining whether or not the judge who set bail, I think Judge Kerry, abused discretion. In this case, your client has violated a 209A order with an ex-wife. That's an order of a court.
I believe he was violated for this charge.
Yeah. Okay. No, I'm actually taking two separate issues. I'm taking that he was on probation at the time. I'm talking, that is a factor, but I'm also saying that and I know we don't apply Section 8 enumerated factors as simply as this, but there's also that there was a violation of a 209A order relative to an ex-wife.
Okay.
That's an order of a court.
Sure.
So what I'm saying is, I understand your views about the strength of the case, and
right.
There's no doubt that's very important, but it's not the only fact.
Sure, it's not the only fact, but in this particular case, I would suggest it has to be the dispositive fact because the other facts are just relatively weak. I mean, so yes, there's a 209A order. So the first question is, like, separate the charge for a second and just say if we have a criminal defendant in general who has a violation of a 209A order in his or her history, is that, and we were going to look at a decision by a judge that, well, based on that, there's nothing other than complete deprivation of pretrial liberty that can ensure you're going to come back to court to face this charge. I think we would say that was an abuse of discretion.
Well, wait. I'm not sure that everybody would agree with that. I mean, violation of a 209A order is extremely serious regardless of the consequences of it. Maybe the person does not end up killing somebody, but it's still a court order they violated. So that's really reflective of their willingness to obey the court, which is why the bail issue then becomes relevant to that, or the other way around.
Fair enough, which is why there needs to be some terms of release that can assure the court that its order that you come back to trial would be respected. But given what this court has said in Brangen about the seriousness of the pretrial deprivation of liberty, I don't think that you're going to say, and I should say that I'm not counsel below, but when I consulted with counsel below yesterday, he tells me that the violation of probation we're talking about is the is the current charge. So, I mean, it all kind of wraps in together about whether the current charge is appropriately being brought. The point
Wasn't there
here,
something, though, with regard to a previous girlfriend?
yes, right, this is
Why-
That's the 209A.
That's what
the
he's talking
existing
about.
order is against a previous girlfriend.
Yeah, I feel like we might be jumping into the details a little bit too quickly, but I just
Yeah,
want to
sure.
go back to my point. I mean, we're dealing with an abuse of discretion. I take into account your arguments about the strength of the case, and just put that aside for a moment.
Okay,
You got a life felony.
correct.
You've got somebody's previously violated a 209A order, which is an order of a court, just like a return on bail. And you've got an offense that was allegedly committed while you were out on probation, and you've got whether or not, in those circumstances, the single justice abused his discretion.
Well, first of all, the question is, of course, whether the single justice committed an error of law or abused his discretion. But as this court said in Brangen, in the cases from which it cited, it's a pass-through analysis here because it's a summary affirmance by the single justice. So you're really passing through and looking directly at the underlying bail order is the first question. So the question of whether Judge Carey...
Go to Judge Carey.
Yeah, right. I mean, it's not to say it's both. They travel together.
But skip that if you want.
So what I'm really trying to do is tease out the basis of pretrial detention for capital defendants and look at whether it's basically being held on a flight risk analysis or are we in some sort of dangerousness claim. And the reason I think that's relevant here and it brings Brangen back in is that in Brangen, the court specifically also talked about 209 or 8 order violations. And when you're talking about that, I agree. Any violation of a court order is relevant, but a default on a court appearance is one thing. And a violation of a 209A order, which generally when people are talking about, they're talking about a dangerousness issue, but we don't have any sort of dangerousness procedures that have been undertaken here. So what we have, and I think we have I think the bail statutes really are just so marginally relevant to the real issues we're talking about when we're talking about bail anyway, because we're really just talking about the due process rules that apply to deprivations of liberty pre-trial. And what's going on is that there's this sort of cross-pollination of, well, there's sort of a dangerousness flavor here. And of course, when you're charged with a capital offense, there's every reason to be concerned to the person about whom there could be probable cause to found that he or she committed murder might pose a danger. But there's a procedure in place to address that potential danger. And there's a procedure in place to deprive someone of their liberty pre-trial on the basis of such a danger. And there's no question that we don't have that here.
Can I ask, can I shift to the big picture for a second? Because your starting point, I'm just trying to make sure I understand it. You're saying, right, that there is a presumption of entitlement to bail and no less restrictive alternative requirement need to be
No, I'm not
found?
saying there's a
I'm just
presumption.
trying to figure out, when we start with the blank slate in one of these cases, forget about the facts for a second. Are you saying, I read your brief to say that you must establish that there's no less restrictive alternative. Am I misreading your brief on that?
Well, I certainly do quote that language, so you're not misreading in that sense. But there's two things I'm not saying. One is I'm not saying that there is a presumption of entitlement to bail. I mean, that is really what the bail statutes create, and that is what existed at common law as to defendants other than capital defendants. So for capital defendants, there's no presumption of entitlement, but there's no presumption of detention either. What there is basically an evenly balanced point at which the government then has the burden of coming forward to justify the deprivation of liberty before conviction. So we're basically at an even balanced point, but the even balanced point results in liberty because that's the fundamental interest at stake.
But can I go one step further? So we don't start with any presumptions. We're at even balance. And does the Commonwealth have some type of burden of showing that no less restrictive alternative needs to be present here? Because that, again,
I argue that they do, and I think...
and
but
what basis do you argue that? What is
this
the
court's due process analysis in Brangen, which really had very little to do with the bail statutes and everything to do with the underlying rights
So
at
you
issue.
say Brangen creates an obligation on the Commonwealth to disprove there's no less restrictive alternative? I'm mostly trying to understand.
Well, the actual quote from Brangen that I mean to emphasize, and I've erred if I've failed to do so, is that it must be demonstrably necessary. And while no less restrictive alternative and demonstrably necessary may be difficult to tease out the difference between, the point here is that there has to be a burden allocated in terms of determining whether or not this person should be released prior to trial on some terms. And the government has the burden of showing that it's demonstrably necessary to keep the person incarcerated prior to trial, and that no less restrictive means in that sense. But that does not mean that the government has the burden of showing that something other than personal recognizance is appropriate. In a non-murder case, then you have the burden of showing that personal recognizance is not appropriate placed on the government. But in this type of case, the government has to show that that only the complete deprivation of liberty is the mechanism by which this
Now,
person can be brought back to trial.
So, when we look back, and you started here, when you look back at the history of bail and context of murder cases, there's no doubt that the judge is going to exercise discretion, and they can't abuse that discretion. But you look at Commonwealth versus Baker, even in United States versus Salerno, it's clear that this common law determination of being able to hold somebody without bail in a murder case existed before the Eighth Amendment, before
Absolutely.
Article 26. It's like the dying declaration with the confrontation clause. So when we start sort of talking about Brannigan and due process, sure, you can't abuse your discretion so much that it violates due process, but we have to realize that there is no constitutional right to bail for somebody who is held under the for murder under at least the excessive bail clause or in the Eighth Amendment or Article 26.
I agree with you, and I think, just to, gush for a second about my love of the law, like that's what makes this case so fascinating, is that it's basically an intersecting of the common law and usage and practice of bail going back, really close to Magna Carta levels, and contemporary understandings of the due process limitations on government deprivations of liberty. That's what makes it so fascinating, because when you look at, and you can look at Murray's v. Hunter Lessee going all the way back in U.S. Supreme Court cases saying, nobody really knows what due process means, but one thing it means is that we as citizens have rights against the government as the same as that people in, under the crown had against the crown. So you didn't have a right to bail in capital case of common law, you had a right to bail in non-capital cases. And you always, though, even when you didn't have a right to obtain bail, you always had a right to seek bail. And the right to seek bail implies a legal standard under which your right to bail, or the possibility of bail, is decided. And what we have in our contemporary understanding of due process is that only has, due process allows pretrial deprivations of liberty in two circumstances. One is the Salerno and Mendoza situation, in which you have ascertainable standards, clear and convincing evidence, dangerousness. The other is flight risk. So by process of deduction, the discretion that's exercised in a capital case has to be based on flight risk. And when you have a person who, respectfully to the seriousness of a 209A order violation, has no meaningful criminal history, and thus really isn't a flight risk under the traditional analysis, we're left with the conclusion that he or she could only be determined to be a flight risk if the likelihood that they're going to be tried, convicted, and sentenced to spend the rest of their natural life in prison is such that any reasonable person in their situation would flee. So I think I can imagine a lot of cases in which that would be the case.
So help me to put back my Superior Court hat, go back to the glory days, and I'm trying a murder case again, and they walk in, and there's a case which is arguably triable, as this case appears to be. What do I do with regard to the bail hearing?
This is what I'm suggesting should be done. I think there does need to be a dedicated hearing on the question of the capital bail. It does not need to be an evidentiary hearing, but I would model it more about the sort of final pretrial memo approach, where each side is going to give a summary of what they expect the evidence to be, and I would hope that the Superior Court judge would meaningfully engage in a back and forth with counsel about both the strengths and the weaknesses of both the government's case, but whatever contrary evidence that the defendant is going to bring forward as well, because that's going to be a lot about the creation of reasonable doubt that will help you assess the likelihood of conviction. I think the Commonwealth has to make the showing that there's a likelihood of conviction under a preponderance standard. And I think that what, for instance, in this case should have happened but didn't is an analysis. Yes, we have these lay opinion testimony about the voice identifications from the video and the visual identifications from the video, and I've submitted the video to this court for review, and I think it's a blurry video is a kind way to describe it, but let's look at the voice IDs. There's voice IDs on both sides. Some say, yes, this was him. Others say, no, it doesn't sound like him. Obviously, the defendant's bringing forward contrary evidence, DNA of other people on the victim's hands, no DNA from the defendant, no fingerprints from the defendant, unknown fingerprints at the scene. These are all problems for the government's case, and I think a judge making a decision about the strength of the case has to, in writing or dictated into the record, address both the pro and the con evidence in order to make a statement about the strength of the case that can be then reviewed on appeal.
Even though we're at the very beginning of the case?
No, I mean, this hearing that I'm appealing happened more than 3 years after he was initially incarcerated and 3 years after he was
But aren't you saying
indicted.
that the same thing has to happen at the beginning of the case too, right?
That's right, but that's why we have a principle of bail review at periodic times, because the case has
Well,
changed.
given all of the bail, you have a right to bail review and can go to the single justice and make your arguments, make the bail argument at any time. What added benefit do you concretely gain by this that would counterbalance the stress on the system, which I know the defendant's rights have to take some precedence, but there is stress on the system when you create this. There's also a public perception issue that gets created by something like this. And they're valid concerns. They may not trump everything, but they are relevant concerns. So how do you make that adjustment?
Well, what I say is, like, liberty is the ultimate right. We have a very legitimate government and community interest in prosecuting serious offenses, particularly homicides. And what we say is that there's a general, what happens, when a person is arrested for murder is they're basically denied bail without prejudice, and they can come back and review it at some periodic time. And I think that the public interest in seeing justice, served in a fair and equitable way is actually, the public interest is actually supported by the idea that periodically, if it's once a year or when there's a serious development in the evidence, that a defendant can come forward and say, Judge, you need to reconsider this pretrial detention order.
But that can be done, can't it?
It can be done, but what I'm asking for is the enunciation of a particular standard under which it's done. And I
Okay,
think that particular standard is necessary to make sure that it's done in a fair and equitable way.
And going back to that standard, so I understand that you're saying that the Superior Court judge should allow a proffer of each side as to the weight of the evidence, and then the judge would make a finding based on the proffer as to what he or she thinks the weight of the evidence is?
I think that's fair.
And then if the judge says, I think it's more likely than not that the Commonwealth will prevail, and therefore I hold him, is there an do we evaluate the proffer and decide whether how do we measure abuse of discretion in that context?
I think there's a two-step process. First, you look at, did the judge actually exercise discretion in a meaningful sense, meaning take a look at what was presented and address it. And then you look at whether if that first step is satisfied, then did the judge abuse discretion? And if the judge satisfied the first step in a meaningful sense, frankly, they're going to have a wide range of discretion. You're not just simply going to de novo everything by the single justice. What you're going to do is say, because if you let me use Judge Carey's ruling as an example. He basically bases his decision not on what was said at the bail hearing. He says it's a strong case for the Commonwealth. I presided, over the hearing of one of the defendant's motions to suppress. Well, what he did at that hearing was he reviewed the four corners of a search warrant affidavit prepared ex parte by a police officer designed to make the defendant look as guilty as possible to a magistrate so they could get his CSLI. Now, we're talking about that order next month, but for present purposes, he didn't address, well, geez, the fact that none of the defendant's, individual fingerprints or DNA are found at the scene or on the victim, but other people's are, how does that weigh into this calculus of likelihood of conviction? I mean, for him to say it's a strong case, I heard the motion to suppress, suggested that motion to suppress, that ex parte affidavit, is a legitimate basis for assessing the strength of the Commonwealth's case. I mean, that ex parte affidavit was written in January of 2015.
So you're asking for a chance to be heard as to the weight of the evidence before the judge, it sounds like.
I am.
Okay, now, you mentioned CSI, and that's not before us, apparently it's next month, but I gather from bits and pieces in the briefs today, or over the weekend that I read, which suggests that he says he was not at the scene, and CSI puts him at the scene.
The CSLI does not put him at the scene. The CSLI is not part of the record, and at least, and again, now I'm outside the record, just talking about my conversations with trial counsel. I'm under the impression that it doesn't, and one of the issues I'm raising next month is that the problem with letting these very weak standard warrants issue for CSLI is that once you have CSLI and it doesn't show someone's at the scene, all the government has to do is come in and say, look how smart and premeditated this guy was. He left his phone home when he went out to kill the victim.
Okay, so going back to your point, then, I'm just trying to think of the remedy, because now there's this part of the record which we don't have, so.
What I like as a remedy is a new hearing before a different judge.
Okay, so you're not asking us to evaluate this record, which makes no reference to the CSLI, you're saying.
The CSLI isn't part of the record before the judge, so I think this court could independently, and I have urged you to, but the remedy I'm really just looking for is a new hearing under an appropriate standard before a
Is there
judge who
any
hasn't
case-
prejudged it.
Any case anywhere that creates this standard you're talking about? I mean, you now
Well, I
have a
do
mur-
cite,
Well, hold on, but just for a second, because someone's facing the possibility of life in prison.
Right.
And we're now creating, is it a preponderance of the evidence? I'm just trying to figure out what we're doing here.
Sure.
In a bail hearing, we're going to assess the weight of the evidence to decide whether, and again, we've got to take into account chance of flight too. What, you know, is the person, this person has an ex-wife in Puerto Rico, does that matter? Does he have family in Puerto Rico? I mean, is that going to shift the weight of the evidence standard?
I think there's, well, I don't think it's
that
gonna
if we have somebody who has a slight flight, maybe it's 40%, someone who has more of a, you know, I just, is this, anyone created such a standard in any state in the United States?
Sure, I do cite two cases that I was helpfully referred to by my sister in her brief that I took a look at, and so I cite the Fry versus State case from Indiana and the Simpson v. Miller cases from Arizona. And those, the Fry v. State says, you know, basically rejects the idea of using a indictment as a proxy for flight risk and says instead you basically need to have a showing in which the judge can, independently weigh the evidence on both sides and make a finding. And then
Is that, by the way, a statutory standard? That
Well,
they're-
one of the things that complicates this, looking across states at this issue, is that many states in their constitutions have this capital case, except where the presumption is strong or the evidence is not great. Standard in their constitutions, 40 states have that, but we don't. So we're outside of that. But that, from what I can tell from reading into the Blackstone and whatnot, that's a common law standard that's been imported into those state constitutions. But because I certainly am arguing that the common law of bail, to a certain extent, is incorporated into state and federal due process guarantees, I think you still need to think about that. And that, again, that comports with this nature and circumstances of the case analysis. We're saying generally in the enormity of this crime, you would think that bail is properly denied, but each case has to be taken on its own facts. So, and I do believe that the Fry v. State case does.
You don't believe you don't believe the standard you just expressed should be the standard, right? That generally you don't get bail.
Well, what I'm saying is the expression of the common law standard as put forward by Blackstone is that given the way these cases tend to shake out, these are my words, not his, you know, it's quite often that public justice would be defeated if bail were granted, but there are cases whose facts justify bail, and in those cases, based on the particularities, bail should be allowed. But the Fry v. State from Indiana does use a preponderance standard, and Carabin from this court, which was applying the bail statutes, but says that inherent power to deny bail resides in the Constitution, not in the bail statutes themselves, also says that a preponderance standard is applicable to facts found for purposes of bail.
Thank you.
Thank you so much.
Ms. McMahon, good morning.
Good morning. May it please the court, Catherine McMahon, Assistant District Attorney for the Hampden District for the Commonwealth. There is no presumptive right to bail in Massachusetts for defendants who are charged with murder in the first degree. Back in England and in Massachusetts common law, bail for a capital defendant is discretionary. In this case, Judge Carey twice had bail review hearings, and he recognized, he cited Querubin, that it was a matter of his discretion. And what informed his discretion was he applied the factors set forth in 276 sections 7 and 8. And one factor is there were 2 restraining orders against the defendant. This victim had a restraining order, and another girlfriend or spouse of the defendant had a restraining order. He violated the restraining order against the other girlfriend before committing this act. He was on probation for that violation when he allegedly committed this act. This act is caught on audio videotape. 3 people recognize the defendant's voice. They're very familiar with him on the tape, arguing with the victim inside her SUV, leaving. A shot is fired. A male figure who they say is consistent based on clothing, shoes, and the way he moves, consistent physically with the defendant, but they positively identified his voice. These are not recipient witnesses to the
Let me just
crime.
ask you, assuming that the judge took all of those things into consideration, even still, do you think that we should be setting out some standards or something to give guidance to the lower
I
courts?
think there already is guidance. There's case law about discretion. There's the factors, the form. He used the court form with the 276, Section 7 and 8 factors there. He wrote down his rationale. He had some familiarity with the case, not only from reviewing the four corners of the search warrant, but in his decision on that motion to suppress. He had also reviewed findings made by another judge on a previous set of motions to suppress. So he had some knowledge beyond the four corners of the search warrant affidavit factually about what the case was about. Also, bail review is usually based on proffers by the parties. There's usually not evidence presented in a dangerousness hearing. Yes, the legislature set out something. This court has reviewed that. And is there standards for how that's to be applied? But here, in a usual bail review, the parties make a proffer. And now we're supposed to, based on a proffer, meet some kind of a preponderance standard. And if it's in writing, is it no longer an abuse of discretion, but is it now de novo review based on the fact that it's documentary? Or, as we know, presentments in murder cases to a grand jury are sometimes 5 to 6 days long. They sometimes involve hundreds of pieces of evidence, some of it videotapes of many witnesses' statements. To have another hearing in front of a judge is going to eat up time.
Well, let me ask you the same question I asked your brother. We're in Superior Court, bail hearing before the judge, case is arguably triable, and this is one of the relatively few cases in which the defense is prepared to make an argument for bail. And there are times in which individuals charged with murder get bail, very
Yes.
often with regard to when babies are shaken and such. I think there are some cases in which there's been bail. Tell me what the judge should do with regard to that hearing.
This is all him, not me. I think right now, the way it is, it's discretionary. You've got the factors in the statute to apply.
Tell me how I should proceed with that hearing if I'm back in Superior Court.
The way the
I will
judge-
certainly give you a chance, you as the prosecutor, a chance to be heard.
And both parties here in front of Judge Carey twice had an opportunity to be heard. Both parties cited portions of the case that they thought were strong for either side. The Commonwealth also argued that based on the fact that it's first-degree murder, it's discretionary, there's an inherent risk of flight, there's a possibility for this as a capital offense, the most serious offense in Massachusetts, that the defendant would never stand trial for it as another factor where there isn't a presumptive right to bail.
Okay, so let's go focus on the due process part. Do you agree that if I, as a Superior Court judge, said I want to hear from the Commonwealth, and then I did not give the defense a chance to be heard, that we'd have a due process issue?
Yes.
Okay, so when I do give a chance for the defense to be heard, is it fair game for them to argue to me, Your Honor, this is a very weak murder case. If you look carefully at the evidence, you'll see that the Commonwealth is not likely to prevail, and my client has every reason to show up for trial because he is convinced, I am convinced we're going to win. Is that a fair argument to make?
I think that's the argument that was made here below.
So, and is it also a fair argument to make to say, Your Honor, my client has extraordinarily strong ties, he has a spouse here, he has children here. When you combine the relatively weak state of the evidence as well as my client's ties to this community, that this should be one of the rare cases in which he should be entitled to bail, albeit with conditions, whether it be house arrest or something like that.
That is a pitch that a defendant can make, and then in this case, there were 2 restraining orders. He violated one restraining order, both making threats about killing his spouses or girlfriends. He was on probation for violating one when he committed this act. And the judge was correct in describing this as an execution-style killing, not to say that the defendant is dangerous, but to say that this is deliberately premeditated murder, that what he's exposed to is life without the possibility of parole.
Okay, so I'm again trying to flesh out what your position is. I understand your view is, yes, there is a due process entitlement to some type of a non-evidentiary hearing that was held here. This is, I guess, the fourth hearing. And do we, by the way, have a record of the earlier three?
We have two. We have the transcripts of two hearings, as well as the paperwork in the record that the judge executed. We have two findings by Judge Carey that are in the record.
Okay, so your argument is, yes, defense has an opportunity, or should have an opportunity to be heard. That opportunity was given, and the judge indeed considered it and made a reasonable determination that the weight of the evidence and the risk of flight, combined with the violations
violation
of the
of a
abuse
court order.
conditions, means it's not abuse of discretion.
Yes, and the defendant has a burden to show abuse of discretion or error of law. He hasn't shown that by either the single justice or the Superior Court justice. He's inventing out of whole cloth a new standard that was not presented to either of those judges. He's based it on case law that from other jurisdictions that have either a statutory presumptive right to bail or a constitutional presumptive right to bail that even applies to capital cases, except for the qualifying language when the proof is evidence or the presumption great, meaning that one party or the other has to show that the Commonwealth's case is strong or that the state's case is weak. Some jurisdictions, and I have a footnote where I've cited to other jurisdictions, put the burden on the defendant. Some put the burden on the state. The Fry case is a good compilation of reviews of other jurisdictions and where they put the weight, even discussing whether it has to be beyond a reasonable doubt, the fact of a grand jury indictment not being sufficient or a grand jury indictment being sufficient. We know that at the grand jury level, even with a 5-day presentment and hundreds of exhibits, it only has to satisfy probable cause. And now the defendant on paperwork wants it to be a preponderance.
Can I ask where you start? The same question I asked Mr. Schnippers. So where do you start? Because I read part of your brief to say that it doesn't even need to be individualized, that basically you could look at the crime without even doing an individualized review and decide no bail.
No, if I said that, I didn't mean
But
that,
where do you
because there was an individualized.
I know there was in this case, but at one point you write in your brief, basically, you can just look at the crime, and that's, you don't, are you saying that? Or I may be misreading your brief, that
The fact that
because
it's
I'm trying to get a sense of where you start. And what, he says there's no presumption. I think he's still arguing that you've got to establish there's no less restrictive alternative. I'm trying to understand where you, forget about the facts, when we begin with a blank slate and a murder, first-degree murder charge, what is the sort of background we start with?
The background is the common law in that in England and in the United States, it was discretionary whether to grant bail to a person charged with a capital offense.
Well, don't you start with, it's not a crime, it's not the crime of murder, it's the nature of the crime that you take into account, and the fact that it's murder means that there's no right to bail, but isn't the place to start, and this is sort of an undercurrent, I think, perhaps, of the appellant's argument, isn't the place to start that the discretion gets exercised?
It's discretionary.
But
and,
no, that it actually gets exercised.
And here we've got
I'm
two
not on a
written
micro
documents
level
that show
now,
that it
I'm
was.
sort of on a macro level. The starting point is that there's no right to bail. It's up to the discretion of the judge, and the judge has to, in the circumstances of this particular case, exercise that discretion, either holding him, as will happen, I'm sure, the overwhelming majority of the time, or determine in these facts, with the exercise of discretion, that there should be a bail.
If the judge had just said it's murder, no bail, then that's not a reasoned exercise of discretion.
Exactly,
And that's not what
exactly.
happened here.
And that's the place to start.
Yes.
But okay, and I agree just the way Justice Lois just formulated that. So what standards? So, okay, so it's the judge has to exercise discretion, has to do an individualized inquiry based on the crime and the defendant's risk of flight, right?
Yes.
And any more guidance than that? I'm just, because
Well,
I don't know how you
the legislature has spelled out different factors to consider, which are on the bail review forms. And the judge considered them, and he checked off some, and he didn't check off others, and he checked them off based on the proffers by the party and whatever review of the defendant's record he made with probation or whatever. But here, we do have a defendant who violated a court order and was on probation for that violation when he allegedly committed this crime, which was caught on camera.
Yeah, no, I get the individual facts are easy in this case in a certain way, but I'm trying to understand the standard is that there's a what risk of flight, a minimal risk, a substantial risk, any risk. I just don't know, when you apply those factors, okay, you've now told us we look at the crime, we look at the penalty, life in prison, we look at the chances of her fleeing. Is there any more guidance we can provide to the judge except for consider those?
Well,
And if you're Chief Justice Gantz and he's been demoted back to the trial court,
It's not a demotion.
what is the standard he has to measure that risk of flight at? It's what? It's a what risk of flight? A risk of flight?
it's an inherent
Substantial?
risk of flight, I submit, in a
What worried
first-degree
me when
murder
you-
case.
So I understand but maybe that's why I got confused in your brief when you said inherent. Because that suggests to me that it's no exercise of discretion, that it's an inherent risk, therefore we deny it inherently. I take it you didn't mean that, but that's what I read it, and I got confused.
There's a built-in risk of flight based on either it being a capital case with the death penalty or, in Massachusetts, life without the possibility of parole.
The building in of that risk
that's-
is just a
that's one
factor that's
factor.
considered.
And it's always there in a murder case.
You just weight it depending on the circumstances.
Yes.
Either weights heavily or it weights not so heavily.
You look at the other factors, and the legislature spelled them out, it's in the bail form.
No, I get it. I just don't know how to measure that risk. Maybe because I didn't do this, but the risk of flight is what? Every risk, there's a 0% risk, there's a 100% risk. There's somewhere in between. I know we don't mathematically do that, but is there a verb, an adjective that we apply to that risk?
I think it's other jurisdictions that talked about the inherent risk of flight. I don't think Blackstone said inherent risk, but the risk of flight is always present in a murder case because of the possibility of life without the potential for parole being the penalty. But it's not like the overriding factor, it's why it's discretionary versus there's a presumptive right to bail. And there are a number of factors to consider. The bail judge did consider them. He didn't simply check off, it's murder, ergo no bail. He thoughtfully weighed them. Under LL versus the Commonwealth, the defendant has not shown an abuse of that discretion, has not shown an error of law by Justice Carey or by the single justice. So I'd ask that the order of the single justice denying the defendant's application be affirmed.
Okay, thank you.